evening. Can you all, oh, there we go. I can even hear myself. Welcome. I'm Bill Brown from Brookings Mountain West. Welcome to our lecture tonight, particularly with the onset of spring break approaching, and more importantly, the Rebels' first victory tomorrow in the NCAA tournament. Right?
From your lips to the great.
Is this real wood? Okay, good. So we have another colleague from Brookings out tonight. Before I introduce him, I'm going to acknowledge one of our guests. Bill Antholwis, the managing director of Brookings Institution, is here, and Bill is responsible and helps us get all our Brookings colleagues out here from all the different programs, and is a senior fellow in governance studies himself, and we hope one day soon to have him back up here giving a talk. So, but let us turn to the topic tonight, and our colleague Philip Wallace, who's going to talk about changing policy without changing law. And some of you may be aware of the current situation in the greater DC area, and using the word change there can be quite difficult, but Philip's found a way around that. He's going to let us in on the secret tonight. Philip's new to Brookings and new to DC, but like our colleagues who come out, he's been talking to students, both undergraduates and graduates, in classrooms and seminars, meeting with faculty, and I know you're going to enjoy his talk tonight, so to keep us on schedule, I'm going to turn it over to Philip.
Okay, thanks. It's nice to be with you all tonight, and that'll adjust. So I want to talk about greenhouse gas emission regulations and climate change in general, but I also want to sort of put this in a context of how policymaking works in Washington these days, a little bit more generally. So I want to go back all the way to the high school civics model of what policymaking is all about. We've got our three branches for our three first articles of the Constitution. Legislative branch makes the laws, executive branch carries them out, judicial branch interprets them and decides controversies. And so the image that conjures up in a lot of people's minds is the Schoolhouse Rock. I'm just a bill. You sort of think policy gets made by introducing bills into Congress and negotiating, and most of them die, but the ones that get through, those are where policy comes from in our system. There's a lot of mysteries in this high school civics model. Where does the bureaucracy fit in? I mean, it's of course nominally part of the executive branch, but then we have lots of independent agencies. Are they completely just wards of the president, or are they some kind of independent fourth branch? When the executive branch goes to carry out the law, how does it know the meanings of the law? It seems like it has to interpret the laws just as surely as the judiciary does. So why are there controversies requiring judicial resolution, and why isn't all the real action about policymaking in Congress? So obviously most of us have something a little bit more sophisticated than the high school civics model when we're following along with the news. But we might go so far as to have what I would call an anti-high school civics model. So that's laws are just bunches of words that the executive and judiciary branches have to make something of. And the world is very complicated and doesn't very neatly match up with the words. And laws are very vague and indeterminate, sometimes on purpose because it makes it easier for Congress to get them through and compromise on something without really nailing things down completely, and sometimes unintentionally because Congress is anything but omniscient in looking forward to the future. So trying to teach the anti-high school civics model to impressionable young high school students would perhaps be discouraging, and it wouldn't make for very nice standardized test answers. Many lawyers also don't like to talk about this anti-civics model. Also, it makes it seem like the law is getting made up on the fly, and they want to say that they're just doing their duty of enforcing the laws, no discretion involved, right? It provides sort of a convenient political shield for them. But the relationship between law and policy is a complex one. The word just in there is a little bit unfair. Laws do instruct and bind a lot of the time, so sometimes the civics model is fair enough. But today, especially, this anti-high school civics model might be closer to the truth for a number of crucial issues. And so to illustrate that, we'll turn to greenhouse gas regulation now. So does the US have a climate change policy? Well, from the perspective of the high school civics model, the answer is barely. We've had a number of statutes passed over the years that sort of give a little funding for research here and there. They sort of plan to plan about what we should do about global warming. So then we've also had some international action. President Bush the Elder signed and the Senate ratified the 1992 UN Framework Convention on Climate Change, which was a non-binding agreement basically saying we're all going to come together and try to do something about this someday in the future. So not really a lot of substance, but set us in that direction. But the Senate completely rejected the Kyoto Protocol that the Clinton administration wanted to get us to be a signatory on. And so there's no binding regulations coming out of those international frameworks today. We've had a lot of bills introduced in Congress, some in the late 1990s, early 2000s, but none of them have passed through and become law. And then we had, of course, in 2009 and 2010, a push by the Obama administration and the Democrats in Congress to get cap and trade, but that did not become law. And we'll circle back around to that later in the talk. But in spite of this lack of sort of civics book policy making on climate change, we do have a climate change policy now. As a country, not all of our policy comes out of Washington, of course, and there's a lot of interesting policy happening at the state level that some of my Brookings colleagues study. I'm not going to mostly talk about that tonight, but that is an important development. And then we have our federal regulations that are now being produced, and they're derived through judicial and executive reinterpretations of an existing law, the Clean Air Act. Okay, so I want to give a brief, at the risk of getting a little deep into the weeds, I want to sort of talk about what the Clean Air Act is all about and how it is that our policies came out of it today. So the Clean Air Act was first passed during the Nixon administration in 1970 at the same time as the EPA was being established and amended significantly in 1977. So those early versions, which gave us a lot of the language that's still on the books today, requires the administrator of the EPA to regulate each air pollutant, emissions of which, in his judgment, cause or contribute to air pollution which may reasonably be anticipated to endanger public health or welfare. So the statute is designed to be able to be applied to different air pollutants as we learn new things about what's harmful, rather than just enumerating a list of which chemical compounds the EPA is to regulate. And this seems like it has a lot of vagueness in it. The statute does provide some definitions, however. We need to think about where it is, how does EPA decide what's an air pollutant, and then what it is to protect public welfare. So the key definitions out of the Clean Air Act, air pollutant, and the term air pollutant means any air pollution agent or combination of such agents, including physical, chemical, biological, radioactive substance, or matter, which is emitted into or otherwise enters the ambient air. Okay, and then there's also a definition for welfare, which clearly includes weather and climate. So out of those definitions and statutory sections, we're going to have the ability to put greenhouse gases under this framework. And in some senses, it seems like they fit. So what's the problem? Well, there are some real difficulties in applying the Clean Air Act to greenhouse gases. First of all, we had another big major amendment to the Clean Air Act in 1990. It was a bipartisan agreement, and it did a lot of big changes. And during those negotiations, Congress debated adding in provisions to address climate change, and they ultimately decided not to. A proposal got spun off and voted on separately during that Congress, and it didn't go through. At the same time, they were putting in some ambitious new programs to deal with acid rain. They have an emissions trading program that came out of that, a Title IV of the Clean Air Act. and they had the implementation of the Montreal Protocol, which is an international agreement to protect the stratospheric ozone layer, to remedy the hole in the ozone layer. And that's Title VI of the Clean Air Act now, and it's been very successful in phasing out CFCs. So the Clean Air Act, the Congress did do a lot of legislating in the old high school civics model way in 1990, but it didn't address the subject of global warming in spite of having considered doing so. More importantly, the Clean Air Act in general is designed to address localized pollution problems. If the air is bad here, then the state and local authorities have to take actions to make it better here. And clearly applying that model to globally diffuse and and the chemical of carbon dioxide, which doesn't affect our breathing in a noticeable way, is a little bit different. So now, how did we get from this difficult situation to nevertheless applying the Act to greenhouse gases? So environmentalists were frustrated with the lack of sort of high school civics progress on dealing with global climate change. So in the late 1990s, they petitioned the EPA and said, we believe it's your legal responsibility to be regulating carbon dioxide and greenhouse gases under the Clean Air Act, and you are, neglecting your legal responsibilities by failing to do so. So the administrative petition is you sort of, before you can sue the agency for not complying with the law, you have to ask them nicely. So that's what they did. They said, we believe you need to do it. The Clinton administration left office without any action. Under the Bush administration, they continued to consider it. Finally, in 2003, the agency issued a very detailed explanation of why, no, they didn't think that they would like to apply the Clean Air Act to greenhouse gases at that time. They didn't say it completely shouldn't apply ever, but they said, no, we'd like to continue to wait and see on the science and wait and see what Congress does. And it's our discretion as to what is an air pollutant. We're just going to hold off. So then we got into the litigation. Having not gotten the answer they wanted, of course, they turned to the courts. And they were joined by certain states in that. And how did they get standing in court? They said there's damage that the EPA is causing them by not regulating greenhouse gases. Basically, the one they settled on in their lawsuit was the loss of Massachusetts coastal land based on rising sea levels that would be a cause of global warming. An effect of global warming. Okay, so that got into the case called Massachusetts versus EPA. So in its first instance in the DC Circuit Court of Appeals in Washington, the court, a three-judge panel, was rather split on whether there really was standing or whether the case was in the right venue, but putting those details aside, they said that they would defer to the EPA's interpretation of the statute. They said, you're the agency, we like to respect how agencies read statutes. If it seems like they're being reasonable, we're going to defer and let it stand. But as the case finally got up to the Supreme Court, 2007 is when that got decided. 8 years after that petition, sort of see the speed of how policy moves sometimes in Washington. The Supreme Court sided with the environmentalists and their state allies, 5-4. Now, I'm someone who believes the politicization of the Supreme Court is often very much exaggerated, but in this case, the division on the court was very distinctly political. It was the four liberal members of the court, Stevens, Souter, Ginsburg, Breyer, joined by Justice Kennedy, and in dissent, Roberts, Scalia, Thomas, and Alito. So it was a very politically divisive case, and the opinions were quite heated. Basically, the majority opinion completely bought the environmentalists' arguments and said, we look at some of that language that I showed you and say, boy, that sure seems like greenhouse gases fit into the kinds of pollutants that EPA should be regulating. We believe that they have a legal responsibility to do so. Or they kind of left the door open. They said EPA could provide some much more substantial reason why it didn't need to do that, but they couldn't just keep saying we're going to wait and see. So pretty much they were going to force the EPA into this business of regulating greenhouse gases under the Clean Air. The dissents argued that the alleged harms shouldn't have had standing because they weren't going to be redressable by a court decision in their favor. In other words, just because the Supreme Court says that we're going to have greenhouse gas regulation under the Clean Air Act, that's not going to help Massachusetts coastal land. They also, on the merits, thought that it was wrong and that those definitions were misapplied. So when you think, I'll go back. This definition of air pollutant is a little peculiar in that it defines air pollutant by reference to air pollution agent. But air pollution agent is not actually defined in the statute. Not exactly a model of clarity in giving guidance to the agency. So Justice Scalia, for whatever you might think of the guy, he's often colorful. He says that by the petitioner's reading of the statute, it would demand Clean Air Act regulation of everything airborne, from frisbees to flatulence. But in any case, the majority had the votes, so that's the law. So what kind of difficulties does this task create for the EPA? So first of all, the petitioners argued their case under a section of the Clean Air Act about automobile emissions. So basically, something we've been regulating all along, and it's pretty natural to regulate greenhouse emissions from cars because it's pretty much the same thing as regulating fuel efficiency. So that's not going to be too much of a problem. But once greenhouse gases are defined as a pollutant for one part of the Clean Air Act, it's not clear how you can say that they're not a pollutant for all the other parts. And when you try to apply all the other parts, there's some real problems, specifically in permitting requirements especially. If you apply the literal language of the statute, it seems like you need permitting for greenhouse gases for all new industrial sources. Maybe that's not so crazy. You need prevention of significant deterioration permitting for about 40,000 sources, which would be a serious administrative burden. And you need Title V permitting for about 6 million sources of carbon emissions in the United States, which is wildly beyond anything which is in the EPA's administrative capacity to do. So that's going to cause some real problems. And then, of course, the other question is how effective is any of this going to be? If we try to put local controls, the machinery of the Clean Air Act is designed so that states bring down the levels of a pollutant below a certain threshold, and that's how they comply with the act. But in this case, it's not really clear where you would set that threshold. If you set it below where it is now, then you're saying if the world doesn't figure out global climate change and reduce the concentration of carbon in the atmosphere, then nobody's going to be complying with the law. If you set it too high, of course, it won't mean anything at all. So it's tricky trying to apply the Clean Air Act to this problem it wasn't really designed to solve. So what have we got under this regime, challenges or not? So we had the Bush administration in its last year started the ball rolling with an advance notice of proposed rulemaking, starting to get a lot of input on what exactly the rules should be. That was all the Bush administration did before the 2008 election. The Obama administration has always said that it's going to be going full speed ahead on this stuff. Full speed sort of being a relative concept again. So we got an endangerment finding in 2009. So that basically says the Supreme Court told us that we needed to decide whether greenhouse gases really were a pollutant. We decide, yes, they were. And it gave all sorts, it did a lot of scientific research and incorporated a lot of the leading scientific research to say why it is that, that increased CO2 levels pose a risk and do in fact contribute to global climate change. So sort of yes on the science, and that means the law has to apply. So then we got stricter tailpipes emissions. These are for cars again. So essentially, we just take the existing fuel efficiency CAFE regime, and we've made it a lot more strict. And the requirements for new cars out now through the 2020s, that schedule, that the CAFE requirements is much stricter now based on this regulation issued in May 2010. Now, as an aside, CAFE standards are not a very good way of getting at, of trying to reduce emissions compared to some other things, but that's sort of the way American policy works. We've got them in place, we ramp them up. So now we also are getting some energy efficiency requirements for new power plants. And those were proposed March of last year, so nearly a year ago, and they're not yet been finalized. There's been some news stories in the paper recently about whether they really are about to be finalized now, if you want to look those up in the last few days. Those would effectively set a threshold for energy efficiency for all new power plants to be built in this country. And the threshold that they've chosen is 1,000, I'm going to get the units wrong. It's 1,000 tons of carbon per megawatt produced, but I might have the units wrong. 1,000 of something. Anyhow, most coal plants come in at about 1,600. Meaning they're above that threshold, they will be disallowed unless they can put in some kind of carbon sequestration technology, which is mostly not commercially viable today. So through this rule that they're in the process of finalizing right now, they're pretty much going to say no new coal plants ought to be built in this country. Now, that's a little less dramatic than it sounds in some ways, because all the power companies today want to build natural gas power plants, because they're more efficient and because gas has become so abundant in this country. And they're more efficient in terms of other kinds of pollution, traditional air pollution. So that's where we are with that rule. Then people are waiting for what would really be the big rule, would be trying to regulate existing power plants. And if they were to take a similar standard and apply it to existing power plants, that would require shutting down or making some sort of big technological leap for a really large percentage of our American power industry. It's not clear how that would happen at the moment. You know, as much as renewables are advancing, coal still is about 40% of power production in the United States today, and much more than that in some regions. We've got a whole bunch of other applications potentially for heavy trucks and airplanes, industrial sources. All those are sort of, at least theoretically, in the works at the EPA right now, although how fast they're coming through is really a question. And now, even though we're only in March of 2013, we just had our election, you start to wonder, will they get through under the Obama administration before that ends in 2017, because that's just the speed these things move at. You have to solicit all these comments from all the affected industries, and you have to answer all those comments. And the EPA puts out these documents that are hundreds or thousands of pages long responding to that. So that's part of our administrative process in this sort of non-high school civics model. When the policy emanates from the executive branch, that's how it does it. So, what about changes in the law? I mean, we've still got our high school civics model that's out there. It could sort of fix all these difficulties and potentially do something more coherent about these problems all the time, of course. And in fact, after Massachusetts versus EPA was decided, almost everybody said, oh, now they'll really have to do something about this issue because nobody wants this Clean Air Act regulation of greenhouse gases. That was the overwhelming reaction back in 2007. You know, here we are 6 years later, and it hasn't come to pass that way. So it did create some pressure. I mean, it was part of the discussion in 2009 as Obama saw it, a cap and trade bill. It was one of the things that allowed the Waxman-Markey bill to get through the House of Representatives. Waxman-Markey included a provision that in creating a cap-and-trade system, it would eliminate most of this EPA regulation of greenhouse gases. That was part of the deal that got the Chamber of Commerce to the table and got them to sort of sign on to letting that bill go through. In the Senate, that coalition did not coalesce. They couldn't find the necessary Republican support. The law fell apart. But it did. The current regime giving us the choice of the status quo or something more sensible instead of nothing or something sensible, right? It did create a little bit of impetus for Congress to pass some law, but it hasn't yet produced anything. So why are we still waiting? Well, one reason is that the EPA is doing its best to minimize the difficulties coming out of this Clean Air Act. So partially, as it's been creating its regulations, part of its strategy is just to say, we're going to ignore the parts of the law that are really, really bad. So all that stuff about permitting that I told you, they basically said, well, that clearly doesn't make any sense, and we don't have the administrative capacity to deal with that. So instead of the thresholds that are in the statute, which are 250 tons per year, which is a lot for conventional pollutants, but not very much for greenhouse gas emissions. So we're just going to make up some new thresholds as we apply this. We're going to call that tailoring the law. And the timing part is maybe we'll get to that other stuff later. So as an administrative necessity kind of thing, they're going to tailor what exactly the law is doing now. So they're going to sort of push the problems down the road and say that they're going to sort of take what's out there and do what they can with it. So on the other hand, if the policies that the law seems to require don't sort of come to pass, how can lawmakers be convinced to act? So petitioners, a new round of petitioners challenging this new EPA regulation say that by ignoring the law, the agency is hurting them by basically making it impossible for them to get Congress to do something about this. Right? They're going and saying, we need to get the law changed, but the EPA is taking Congress's motivation to do that away from them. And that's hurting us because we think the law is going to be changed in a way that's favorable to us, the industries. So this industry group that sued, they recently lost, though, in the DC Circuit. And the DC Circuit actually cited Schoolhouse Rock in their opinion. They said, you should know, petitioners, that getting a bill into a law is a very difficult process. And you're just sort of speculating about what would happen if you were oppressed by this literal application of the law. And in fact, we know that you're glad that you're not being regulated as much as the law requires, so you don't have standing to challenge this. And that's where things stand since that DC Circuit decision came out over this past summer. Well, maybe that's just the way things are when you have a dysfunctional Congress. These are two books by my colleague at Brookings, Tom Mann, and his counterpart at the American Enterprise Institute, Norm Ornstein, talking about the dysfunction in Congress. This was 2006. Congress was just broken. By 2012, it's even worse than it looks. It's gone downhill even from there. And of course, a lot of their diagnosis is that the Republican Party has just become especially historically extreme. So what are we supposed to do with this dysfunctional Congress? Is that sort of good riddance to the high school civics model as long as we've got a Congress like this? Just cut Congress out of the loop, basically? Well, I don't know. As naive and optimistic as the high school civics model was about Congress channeling the will of the people and that being where policy comes from, the story of greenhouse gas regulation as we have it now sort of stands at the opposite extreme. Shutting down the ability to build new coal power plants without Congress ever having made a decision to that effect really does create a pretty dramatic situation where industry can say a huge policy has been made completely outside of the democratic process, and that's not how it's supposed to work in the rule of law in America. But from the executive branch's perspective, they're trying to sort of use their prerogative to do the best they can with the legislative tools they have. And you know, what else can they do? You know, and the fact that they don't seem to be sort of acting as good agents of what congressional will is sort of secondary to them. This is definitely a pattern that we see playing out in other policy areas apart from greenhouse gas. In No Child Left Behind was a particularly crazy act of high school civics book policy making. In the very bipartisan moment after 9/11, you had a very broad coalition come together to pass something to support accountability in schools. That's a great idea, but the way the act is set up, it would keep ratcheting up its standards until way in the distant future, around 2012, 2013, every student would have to be proficient. Every single one. Or else school districts would be they would be in non-compliance with the law and fairly dire consequences would follow. Well, it turns out we haven't figured out a way to make all of our schools get every student up to the level we would like them to be. So that can do one of two things. It can erode standards. We can just make the standards so low that everyone can pass, or it can cause this problem where suddenly everyone's non-compliant. Well, seems like Congress should fix its own mess. But again, that's not really what's happened. Instead, we've gotten a regime of waivers at the Department of Education where the Secretary of Education sits down with each state and basically negotiates a plan where they say, here's how we're going to do accountability. Does this sound okay to you? And he signs off on it and they say, okay, forget about what the law actually says. That's sort of how we're coping with No Child Left Behind today. The BP oil spill was a pretty dramatic moment. It didn't really generate a legislative response either. It generated some interesting executive branch-led creative solutions. So it created a huge fund and a special czar to oversee the dispersion of those funds to people affected by the spill. There was a drilling moratorium instituted without any particular legal authority, actually, and the Obama administration actually ended up being held in contempt of court because of that, and then finally just said, oh, forget about this moratorium. We'll go on and other people get judged on the things that are in the law. Immigration reform is another one, right? Everyone the support for this idea of the DREAM Act, letting people who get brought here by their parents as very young people and then play by all the rules, they ought to be treated like citizens, put on a path to citizenship. Well, that's a very popular idea. The Congress hasn't gotten its act together to pass it through at this point. Maybe it will in the next little while, but for now, the Obama administration has said we're going to essentially at least make sure these people are not getting prosecuted just for being undocumented by changing our own prosecutorial strategies and enforcement strategies. That's within our discretion as the executive. So what should we make of this pattern that's so completely divorced from the high school civics model? Well, we can fall to some pretty hyperventilating generalizations. Are we sort of in a new era? Is the rule of law and democracy behind us? Policy sort of generated of its own accord in the executive branch? You can read a version of this in House Majority Leader Eric Cantor's office, put out a document during the election that was entitled The Imperial Presidency, and sort of goes through the Republican policy agenda and fits it into this framework of sort of the executive branch run amok. That's sort of been a theme in political science over the last 40 years, is worrying about this. And I'm sort of not inclined to say we need to act like everything is falling apart or something so dramatic is in order. But I think we do have to think about the disadvantages of making policy in this manner. And can it really work, and can it be sustainable across a broad variety of important policy areas? So first of all is you do have to comply with the existing laws at some level, and you can't make them say something completely different from what they say. Well, maybe you can, but not usually. And so that creates some real problems. At some level, our political system is built to need Congress to act. So just cutting them out of the loop completely is problematic. And then the inefficiencies of the kinds of system that we're creating through the Clean Air Act, for example, they create some real vulnerabilities for the policy area more generally, right? I'm a really big believer that we really need to be acting on climate change, and we ought to be doing so in a coherent, smart manner. But in all honesty, you can't really defend what's coming out under the Clean Air Act as coherent and smart and what we ought to be doing. It's not. It's sort of a jerry-rigged alternative that's not second best or third best, but 10th best. And if we're prepared to live with that, we should probably admit that we would much rather be doing something else, like replacing it with a carbon tax, like my colleague Adele Morris, who came here last semester, talked about. And then you have to wonder at some level will the voters rebel against this regime? Do they feel like they've been cut out of the process? They've sort of don't have the ability. Of course, they get to elect the president, and that makes a huge amount of difference. But is that level of accountability enough? Really, how many voters were thinking about this when they decided who to vote for president? Very, very few, right? It's made on a much different plane of thought. So if their ability to petition their representatives in Congress sort of doesn't have anything to do with how the policy is really being made, at some point will they rebel against that? So that's all I've got for my main talk, and at this point I'll be happy to take whatever questions people have. Yeah.
Yes, well, it's a fascinating talk, and I know we talked a little bit offline. On the other side of the coin, it's been very interesting, actually, again, going back to Ronald Reagan, but what's happened with the FTC, Federal Trade. I don't know if you've looked at that at all, but back under, well, I get that's kind of my question, but back under Reagan, he decided that the variance was the accurate measure of monopolies rather than the 50%. So he went from 50 to 70. And just in recent weeks, I noticed that the Obama administration issued a regulation saying that they were only going to impose anti-monopoly and so on if the people bringing the suit could show that they were significantly damaged by, we're not going to limit it to 50% or even 70, we're just going to make sure that you can really show, oh, you're hurt badly by this. So anyway, my question is, the FTC is kind of going the other way. It's been largely emasculated compared to what it really, or is it?
Well, I mean, so antitrust law is it. I'm not at all an expert on antitrust law, but I can say a few things. That antitrust law is kind of the quintessential policy and the historical forerunner of the non-high school civics model in some regards, because the Sherman Act says that there shall be no unlawful combinations in restraint of trade, and that has a tradition in the common law. So that is a bit of a term of art, but nobody really had any idea what that meant. So passing the Sherman Law back in 1890 was a way for Congress to approach this pressing issue of the day that the public was torn in all sorts of directions about but felt very strongly about. So they passed a big act that sort of said, we're going to do something. And then the courts spent, the next 40 years figuring out exactly what that meant. And then in the 1970s and 80s, there was really a big revolution about thinking about what the purpose of antitrust law was. And one way to look at it is that they dismantled it and vitiated it. And the other way of looking at it is, God, there was this oppressive regulatory regime that didn't really accomplish anything. And thank God, now it really only kicks in if it's really going to help consumers instead of sort of serving some idea about how industry should look. So that because of the way that the antitrust statutes are, though, I think antitrust policy is destined sort of to be driven from executive branch reinterpretations of what the policy ought to be doing. And in a sense, that's what the law gives us, and so that's what we're going to get. Yes?
Could you give us a few pros and cons of the carbon tax?
Sure, I would love to. So I may not give you too many cons, though, because I think it's a really good idea. When we think about how we would like to be addressing greenhouse gas emissions. Basically, it's a very classic economics externality, right? Where we say the true social cost of this activity is not being borne by the people undertaking the activity. We want to internalize the cost so that they take into account, you know, how their conduct hurts others in society. That's sort of as classic an example as you can get of an externality. And so the way of addressing an externality is to put a tax on it. So they have to internalize that cost. So it's tricky to figure out what the right price should be, what the real cost is, how we should price that. But sort of in the spirit of not letting the perfect be the enemy of the good, setting some kind of price really makes a whole lot of sense from an economics perspective, from an efficiency perspective. It's also just economists of both parties really like a carbon tax as something that's pretty efficient. Basically, economists tend to like consumption taxes compared to income or payroll taxes. Why? Because income taxes, when you put a tax on something, you get less of it, generically speaking, other things being equal. So when you put a tax on income, you get less of income, and we don't really want that. Consumption, discouraging consumption compared, that helps us push people toward investment. So there are some questions about the regressivity of a carbon tax, but there are ways you can deal with that. You can rebate some of the money you get from the tax to everybody so that you get a carbon check in the mail, not based on your usage, of course, because that would sort of defeat the whole purpose, but just everybody gets a check, which would make the regressivity a lot less. So I don't know. I'm not the absolute authority on this. If you want to read about a carbon tax, you should definitely look up my colleague's work at Brookings. Adele Morris is her name, and she's just doing great work about all the advantages a carbon tax provides. And of course, from our fiscal perspective, a carbon tax is also very attractive because we really need sources of revenue these days. And this is a sort of a good one waiting to be picked up. Yeah?
So if you were a park ranger at Glacier National Park and giving a program to the public, and you're passionately like, hey, you know, I'm hired to protect these glaciers, what would you say to the public when you're trying to provide them with some meaningful action that they could take? As far as meaningful policy action, because you are an expert in the policy area. I mean, sure, you can bring your own grocery bag to the grocery store, but really the scope of the problem doesn't seem to really fit that suggestion.
Well, sure. I mean, at some level, we need a wholesale change in everyone's behavior, and we think that just asking people nicely is a little naive in terms of ways of pursuing that. I mean, at the same time, why shouldn't you turn the light off and use a reusable grocery bag?
Right, I'm
but
not saying those are bad suggestions, but from what can a park ranger say to the public about what action they can take to try and influence these?
I mean, really, they need to put pressure on their Congress people to get back in the game. And that means making it a priority on the Democratic side, where it's not always clear that it is a top priority, because some Democrats seem to be thinking, oh, we'll just sort of let this come out of the EPA and that's that. And on the Republican side, saying, listen, we're gonna end up doing something on this issue. We should do something smart, and we should do something that's beneficial to our society in general, like a carbon tax. And the fact that the second word in carbon tax is tax should not stop you from doing that, because this is good policy for our country. So, you know, that I don't know how naive and idealistic that is, but
Saying the suggestion is letter writing. I mean, is that the most effective thing, or is it funding some of these litigants to kind of force action, or you know, like donating to a nonprofit that's going to bring a suit? Would that be more effective than letter writing, or letter writing and doing that?
well, the future litigation has kind of an ambiguous role in all of this. So there's a nonprofit group that's based out of Washington, I think. It's called the Center for Biological Diversity. And they take the position that the EPA is not doing nearly enough, and it should enforce these regulations to the full extent that the literal language of the Act requires. And so there's a question of whether they're going to sue the EPA and force them to do more. Now, personally, if I were somebody who wanted at least the EPA to be doing something, I think that's a terrible strategy, because that's doing exactly what the industry groups want, which is to make this completely intolerable so that Congress really will come in and do something. And we know what the Republican House of Representatives wants to do. They passed a bill in 2012 during election season called the End the War on Coal bill or something. And part of that bill is to say EPA has no jurisdiction over this at all. And it, of course, won't be replacing it with a carbon tax or anything else smart. It will just be saying, this is bad policy, get rid of it. So my sense is that democracy has to make this work and come through the Congress in the sort of traditional policy-making way for this to ultimately get sorted out. So I don't know. I don't know whether in this day and age telling people to try to push their congressman to do something just sounds really hopelessly naive in itself, but that's my advice.
Okay, thank you.
So letter writing, I think.
Letter writing, yeah.
Yes.
Sounds like it.
Yeah.
Yeah, a couple of things. There are, as far as I know, 3 examples of areas in the world where carbon taxes have been implemented already. Australia, within the last year or so, which is doing well. Ireland, which is actually using some of that money to help dig itself out of the economic hole that it's been in through these misguided measures of austerity, and British Columbia. I just wanted to, if people want to look that up, they can see how real-world examples are going there.
Yeah.
Conservatives railed in Australia that the whole economy would fall apart. Instead, of course, they're seeing some positive benefits at this point.
Well, I think in Australia it'll be interesting to see whether it sticks, because there is a big political backlash against it, and my understanding is that the government has kind of retreated in some amount. So you got to get the politics really getting behind these things before you can put it. British Columbia is an interesting example, though, because they have one of these rebate programs where everybody gets a carbon check, and perhaps not surprisingly, that makes the policy a lot more popular. So I think that's a promising model, yeah, that people should be looking into.
Instead of a carbon tax, call it a carbon rebate program.
Sure. That's cap and rebate is what sometimes call it, tax and rebate, yeah.
The trouble with the cap and trade is that the poor get capped and the wealthy trade. Oh, well, I think I can see where if you have a basic, but things like sales taxes, those kind of taxes, again, are classically, there's more and more data, classically regressive. So the thing is how to, and again, I guess it's really hard to try to approach producers and, to try to find a way to put the taxes, the penalties on the producers, even the investors, if they're going in the wrong direction. Is there any thought about that kind of an idea? I know that would probably be hard to do.
You're basically saying something like, you want this to come out of profits.
Well, out of margins. No. In fact, on some of my trade things, I've specifically said that trade policy changes have to come out of the margins. No, that it would have to come out of the margin.
So the difficulty, of course, is that industries pass things through to consumers by price increases, right? So that's the trick, and unless you adopt some pretty draconian policies dictating what prices can be set in all these different industries, that may be something you have to live with. So I do think you should read some of the work from Adele Morris on this regressivity question if it bugs you, because there's a lot of people thinking about how to mitigate that, and I don't think it should be sort of a fatal objection.
Also depends on elasticity of demand as well.
Yeah, sure. In the back, sir.
Even if we have a perfect system and the classic school, all the factors worked, globally, we still have those elements of India, China, a growing world population, a demand for energy. So at what level do we have to bear a cost because we alone are not in this problem?
It's a terrific question, and I was teaching a class of some UNLV students earlier today where I tried to think about the problem just from that angle. So India has approximately 400 million citizens who don't have regular access to electricity. So they have very low per capita carbon emissions in India. But obviously from most of those people's perspective, they want to be using a lot more energy and not less. So figuring out how to bring India and China into some global scheme that really has a chance to actually level off emissions at a global level or even start pushing them on a downward trend is really, really hard. So I personally think it doesn't do those of us who want to see some solution, I don't think it does us any good to pretend that we're almost there or that we've almost figured out how to answer your question. We haven't figured it out at all. Getting a really politically sustainable solution is going to require a lot of really creative thinking about how to make it worthwhile for the citizens of those countries to participate in something, and I don't think we have an answer yet. So,
in fact, in terms of the environmental impact, we were talking. He just mentioned that too. Is the fact that these populations in India and China, particularly in India, as those glaciers accelerate, it's really going to be just a decade or two until those water.
Yeah, I mean, I think India and China are not indifferent to these problems, right? So they're
trying to work, and I think
yeah.
they really need to be brought in. They can't give an exemption, and they're going to have to really, even if you have to tie it to various things like trade. And so I think there really will. Oh well.
Yeah, no, I don't mean to end on such a gloomy note, and I do think there's a place for the U.S. to sort of lead by example as it tries to bring these other countries into some more universal solution. But it's definitely going to be a real challenge. One last question? Or?
Please, is there one? There we go. Please.
You're looking into the light. Are you familiar with, or can you tell me anything about the group that calls it 350.org?
Just a tiny bit, and I think we're already past 350 in our global carbon concentrations right now, and in my own view, hoping that we, thinking that if just enough people sign their petitions, that we'll get back to 350 is a little bit too optimistic for me. So I think yeah, we have to acknowledge how hard it is. We have to acknowledge that we're on an upward trajectory, and part of that is because some things are going right in the world, and in the developing world especially, right? And we have to sort of be realistic about where we can get going forward.
Thank you for all your good questions. Thank Philip for his innovative civics lesson that we got.
Thank you. My pleasure.
We are off next week in terms of our lecture schedule, but we're back in exactly 2 weeks, which will already be April 3rd, and we'll take a different subject in mind. We'll be honored to have Domenico Lombardi out from Brookings, and he's going to take a look at some world economic issues and the euro crisis. So I hope you can all join us then. Thanks again for coming.